If you've agreed to be a guarantor for somebody renting a property, there might be a hidden trap that you need to be aware of. But first of all, what is a guarantor? A guarantor is someone that's agreed to pay the rent in case the tenant doesn't pay it. They might also have to pay for repairs to the property or damage to the property, depending on what the guarantee agreement says and what the original tenancy agreement says. Although it can't bind the guarantor any more than the original tenant, there are a few things to look out for. The big one to look out for whom is the guarantor responsible? Because if this is a joint tenancy and there are 2 or 3 or even 4 tenants within that property, and the guarantor is signing on behalf of all of them, that could create quite a significant problem, because then the guarantor might be responsible for the rent for each and every other tenant, in addition to the one that they thought they might be guaranteeing in the first place. This is particularly prevalent because I've received a number of emails asking me to do a video on this very subject from you guys, my viewers, because lots of students are now in that process of renting properties, of course for their university accommodation. They usually go to the bank of mum and dad to be the guarantor for their tenancy agreement. However, in order to avoid this trap, you need to very carefully check the guarantee agreement and the original tenancy agreement to see whether it's a joint tenancy or whether they are individual tenancies, which is what I would recommend, and whether the guarantor is only guaranteeing the tenancy for one of them that they intended to guarantee it for, which again is what I would recommend. I would not obviously recommend that a guarantor guarantee the entire agreement for every tenant on a joint tenancy if they have nothing to do with any of the other tenants, i.e. in this situation, the other students renting that accommodation. At a bare minimum, the guarantor should be reading and checking the guarantee agreement before signing it, but they should also be checking the tenancy agreement, for example, checking rent review dates and whether it is a fixed period tenancy, which again is what I would recommend, rather than an ongoing tenancy for which the guarantor might be liable until that tenancy ends. Remembering, of course, that most guarantees for tenancy agreements will usually cover unpaid rent or damage to the property. However, there are a couple of defences in this situation, for example, disrepair of the property or a claim for the breach of the rules against tenancy deposits. However, it's important to remember that a guarantor cannot bring a claim for the breach of the tenancy deposit unless they have paid it on the tenant's behalf. And finally, if you are a guarantor that feels you've been pressured into this situation, or you haven't had time to consider it, or you haven't taken legal advice, there are some situations that might be considered undue influence. This is where the guarantor might have a defense against any such claim for undue influence if, for example, the tenant has a dominating influence over the guarantor. For example, the guarantor wasn't given any opportunity to consider the decision, haven't taken legal advice or had the opportunity for legal advice, or in some other way that the court might consider to be vulnerable. So overall, my overarching advice is always read the documents before you sign them and be absolutely sure what it is that you are signing. Always take advice if you're unsure about what you're signing, and ultimately, if you're not sure about it, don't sign it. But I do hope this video has been somewhat useful to you. Remember the big trap that if you are a guarantor, signing a guarantee on behalf of multiple tenants that you didn't intend or didn't even think about until you watched this video, please do share it with somebody and make sure you subscribe. But thank you for watching, and I'll see you next time.